The President, please be seated. The court is now in session. During today's session, we shall begin with the statement by Nguyen Chia. The statement he is going to make concerning the testimonies of Mr. Kang Kek Eo alias Dutch. Then we shall proceed to the questioning of Nguyen Chia by the bench. Should Nguyen Chia wishes to respond to questions. The chamber also plans to hear testimonies of the witness. The chamber has already informed to the party. These witnesses will be heard immediately after, for example, Nguyen Chia has reserved his right not to respond to questions if he wishes so. The court officers or greffiers are now instructed to report to the bench on the presence of the parties to the proceedings. Mr. President, Your Honors, the co-prosecutors are present. Mr. Nguyen Chia, Ieng Seri, and Khieu Samphan are present. Counsel for Nguyen Chia is present. Counsel for Ieng Seri is present, but only his national counsel is present, while counsels for Khieu Samphan is present. TCW 617, who is a witness, is now ready to be called. This witness has no relations to any parties to the proceedings and has taken an oath already. The President, thank you. Security personnel are now instructed to bring Nguyen Chia to the dock.
Mr. President, good morning, Your Honors. Good morning to all the parties and good morning to the wider public. I have a few short comments to make before we turn to the questioning of Nguyen Chia. If you would allow me 2 minutes to do so. We have received the email from the senior legal officer informing us that we are not allowed to make submissions this morning, and naturally we will respect that ruling and we will not be making the submissions that we were planning to make. Just for the record, we wish to state that these submissions would have dealt with some important fair trial concerns that came to light during the questioning of Duch, and it is our position that submissions like these relating to fair trial concerns must be discussed in open court, in public, for the wider audience to see and hear. And we feel that a public trial means that defense concerns as to the violation of our client's fair trial rights should be discussed in public, and fair trial observations should not be relegated to written submissions. I thank you. This was all for us before we turn to the questioning of Nguyen Chia. I thank you for your attention.
The President, Mr. Nuon Chea, you may proceed. You indicated before the chamber heard testimonies of Kang Kek Yew alias Duch that you would wish to make some statement. You were not allowed to do that, and that you were advised to take the opportunity of the conclusion of Mr. Kang Kek Yew alias Duch testimony, then you could make your statement. The chamber found it difficult to offer you the opportunity to give the statement before we concluded the hearings before the Khmer New Year. So today we are now offering you the opportunity to make your own statement or observation, should you wish to do, concerning the testimonies made by witness Kang Kek Yew alias Duch. You may now proceed. Nuon Chea, Mr. President, Your Honors, and my respected fellow Cambodian citizens, I will be very brief, but my comments will be genuine and with a sense of justice. I would like to inform the Cambodian people that I have never had any time ever been responsible for the operation of S-21. What Duch has accused me has been untruthful and very unjust towards me. I have never ordered, I have never received any documents from Duch, and I have never been the superior of Duch. Duch is a person good at speaking. He has been a very experienced person. He has engaged in several court proceedings. He at times confused. He could not even remember clearly the annotations made on some documents. He has mistaken annotations made by Pol Pot for my annotations. May I therefore ask that the bench or the court set aside all the accusations made by Duch against me. If I had made such annotations, I would like to ask that Duch bring them before me. I wish also to inform the chamber that I am not willing to respond to any questions by any party for the time being. Thank you, Mr. President, and Your Honors. The President, Mr. Nuon Chea, are you now reserving your rights to not to respond to parties? We understand that you are, but what about the response to the questions by the bench? Do you also wish to reserve this right not to respond to them? Nuon Chea, Mr. President, I do not think I understand your question properly. The President, just now we have heard that you reserved your right not to respond to questions made by parties in the proceedings. The Chamber wishes to also inform you that the bench or the Chamber is not a party to the proceeding. The Chamber, in particular the bench, is here to adjudicate your case. And we heard that you only reserve your right not to respond to parties' questions. What if the bench puts questions to you? Are you also reserving your rights not to respond to such questions from the bench? We have already made clear that after your statement, the Chamber shall proceed to put questions to you concerning the facts. In the second segment of the trial of case file 002/1, could you indicate to the Chamber whether you are also reserving your right not to respond to the Chamber as well as the parties altogether? Mr. Nguyen Chia. Mr. President, may I have a moment with my counsels, please? The President, you may have that moment. The President, security personnel may retire so that Nguyen Chia can have some moment with his counsels. The President, could you ensure that your mic is activated before you speak? Mr. Nguyen Chia, Mr. President, I would like to reserve my right to remain silent. The President, is it clear now that you reserve your rights not to respond to even questions by the bench? Is that so? Counsel for Nguyen Chia, I think I may need to discuss this with my counsels first. The President, did you have that discussion, or would you wish to have another moment with your counsels? Please listen to my question again. The Chamber has noted your statement. You indicated that you would like to reserve your rights to remain silent or not to respond to questions by party. The Chamber has noted this very well. But the question is, if questions are to be put by the bench, the judges of the bench, are you willing to respond to questions by the judges or not? Because today's proceedings are dedicated initially by questions by the bench, and you indicated you exercise your right to remain silent. We just would like to know whether your exercise of right to remain silent applies to questions put by the judges as well. Mr. Nguyen Chia. Mr. President, I would like to state again that I would like to reserve my right to remain silent. The President, thank you. We have noted your position. Co-prosecutor, we note you on your feet. You may now proceed.
Thank you, Mr. President, and good morning. We just want to make our position on this issue again clear. There is a pending motion that addresses this. This is even more disturbing as the Nuon Chea team was put on notice. They were put on notice that if he made his statement this morning, that he was to be subjected to questioning. And knowing that, he proceeded to make a statement and then to refuse to answer any questions. As set forth in our motion, it is simply not proper for an accused to waive his right to remain silent, make a statement to the court that he is innocent, that he had nothing to do with S-21, that his accuser is a liar, and then to refuse to answer questions. There are consequences to this. As we have submitted, there can certainly be no weight to his exculpatory assertions. And we would also...
The President, could the co-prosecutor hold on? Nuon Chea appears to have a problem hearing the rendition into Khmer. Court officer, could you please ensure that his headset's battery has not yet run out? The President, Mr. Nuon Chea, could you please indicate to the chamber whether you have missed the whole statement made by co-prosecutor, or you heard partial of the statement? Mr. Nuon Chea, Your Honors, I have not heard anything from the co-prosecutor. The President, co-prosecutor, could you please repeat the whole statement?
Yes, thank you, Mr. President. As I said, there is a motion pending on this, but it is clearly not an acceptable practice for an accused to waive his right to remain silent and make a statement to the court in which he effectively says, I did not do it, I had nothing to do with S-21, my accuser, Deutsch, is a liar. For him to make an assertion like that and then to refuse to answer any questions to test his assertion. As per our motion, there are consequences when an accused attempts to engage in gamesmanship like this. There certainly can be no weight afforded to his exculpatory assertions, and it is also our position, as set forth in our motion, that negative inferences can be drawn when an accused refuses to answer questions. So it is important that the accused be on notice of this, and at this time we would like to revisit this issue after the trial chamber rules on our motion, at which time the accused may wish to reconsider his position and answer questions. And certainly we would like to make a record of the types of questions that the accused is unwilling to answer relating to this matter. But I would submit the best time for that is after the trial chamber has ruled. But we want our position on this matter to be very clear. Thank you, Mr. President.
The President, thank you, co-prosecutor. Lead co-lawyer for the civil parties, you may now proceed. Counsel Sonaron interrupts. May I respond to the co-prosecutor?
Yes, Mr. President, Your Honors, good morning to you all. Allow us, on behalf of the civil parties, to show how indignant we are regarding this position. We are also indignant from a legal standpoint. Mr. Nunchia is of the view that whenever he wishes, he may make statements, come out of his silence, say a few words, and then go back into his silence. Now, the first question that arises is, what is the possibility he has to make statements? What is this right he has to make statements whenever he so wishes? What is the legal status of such statements? It is not provided for in the internal rules that he should behave in this manner. And in particular, besides that, Mr. Nunchia is of the view that he can avoid all confrontation, that he may make statements whenever he so wishes, whereas confronting others, confronting witnesses and the parties is the duty of all parties here, and it is also part of a fair trial. Due process is not only the right of the defense, it is also the rights of the civil parties. It is a right recognized for everyone, and if Mr. Nunchia continues to speak as he is doing, only when he so wishes, without accepting to take questions, he is not complying with this essential rule, which is the rule of due process, Rule 21 of our internal rules. Let me add this. Mr. Nunchia always takes refuge behind his right to remain silent. I think one thing should be clear. The right to silence in civil law is not only the right to silence in common law jurisdictions, because in common law jurisdictions, when an accused person speaks, he speaks under oath, and here he is not speaking under oath. And anything he says without taking an oath, that does not have any weight. And the right to silence is not an absolute right, which is over and above the fair trial rights of all the parties. And he is avoiding his obligations to take questions in due process. So it is completely unacceptable for an accused person to make statements without accepting to take questions and to be contradicted. And in future, the chamber should not grant such rights to the accused whenever they wish to make statements without taking any questions. I thank you.
The President, Counsel for Nunchia, you may now proceed. Counsel Son Arun. Mr. President, Your Honors, I would like to respond inclusively both to the civil party lawyers and to the co-prosecutors. Mr. Nunchia has made it clear that he would like to make a very brief statement of about 3 to 5 minutes. He did so. He asked that at the beginning, before testimonies of Mr. Kangek Eo Elias Deutsche was heard, the President said that Mr. Nunchia could do so at a later date. We fully respect the call of the chamber, and we never disrespect the chamber as what counsels, my learned colleagues, indicated. And last week, we also heard that Nunchia wished to do so, and that the chamber only allowed him to make his statement today. His statement was brief. He prepared in writing, and it was shorter than a page long. And he only wished to respond to the accusations made by Deutsch. And he made it very clear that he would like to reserve his rights not to respond to the parties and to the chamber. He indicated that with regard to other questions, he would like to consult with his counsel. It doesn't mean that he will reserve his right to remain silent all along. He only wishes to consult with his counsels when time fits. Thank you. The President, Mr. Co-Prosecutor, would you wish to raise a new issue if you are willing to go into the same issue, then you are not allowed to do so, or unless it is new?
No, Your Honor. I just wanted to remind the trial chamber and our counsel that the court had issued a memorandum last week that said that if the accused made a statement that he was to be subjected to questioning. That's all. Thank you.
Security guards and people who take Mr. Moon back to his seat behind his counter. As to translation, this will be
Vậy là đi dừng một to từ cái chấm nào cả sắm cá sập sập khai cam.
The President, the chamber now proceed to hearing the testimony by the witness scheduled to be heard today. Since the accused Nuon Chea exercises his right to remain silent, the chamber will summon witness TCW 617 to this courtroom, and the chamber wishes to advise the parties in these proceedings that in the event when the accused exercises his right to remain silent, the chamber will render a decision on the matter after coming back from the break. Court officer is now instructed to bring witness TCW 617 to the courtroom. The President, court officer, please ensure that he has the headset ready so that he can listen to the interpretation. Mr. The President, good morning, Mr. Witness. Can you hear us? What is your name? Response, my name is Tương. The President, please make sure that you answer when your microphone is activated. The President, what is your name? Response, my name is So Tương. Question, do you have any alias? Please wait until your mic is on before you answer the question. You do not have to rush. Please be relaxed in answering the question. Do you have any alias? No, I don't. Question, how old are you now? Respond, I am 62 years old. Question, what is your occupation? Respond, I am a farmer. Question, what is your father's name? My father responds, my father's name is Ja. Question, what is your mother's name? Response, Yim. Question, how many children do you have? Response, 9. Mr. So Tieng, according to the report by the greffier, according to the best of your knowledge, you do not have any relationship with the civil parties and charged persons. Is that correct? Response, that is correct. And the greffier also indicated that you have already taken an oath. Is that correct? Response, yes, that is correct. The President, before putting question to you, the Chamber wishes to inform you your rights and obligations as follows. Mr. So Tieng, in your capacity as the witness in the proceedings before our chamber, we wish to advise you that you may exercise your right not to self-incriminate yourself when answering the question. It effectively means that if any statement you make may incriminate you by any ways, then you may refuse to answer that question. However, as a witness, you also have the obligation to respond to questions put by the parties and the chamber. Except when those questions may incriminate you, as I have already advised you. And you shall tell the truth and nothing but the truth. based on your personal experience that you have come across.
លោកយល់ដែរទេអំពីសិទ្ធិនិងករណី
Do you understand these rights and obligations? Response: I do not thoroughly understand.
យើងបញ្យល់លោកថាក្នុងករណីជំនួស
The President: Again, whenever the question put to you may incriminate you, you may refuse to answer to those questions. That is your right.
អនុវត្តសិទ្ធិឆ្លើយតបក៏មិនមានបញ្ហាអ្វីដែរ
However, you may exercise your right to respond to those questions, but again, you may reserve your rights not to respond to any questions that may incriminate yourself. However, you are supposed to tell the chamber the truth, nothing but the truth, from your experience that you have come across or observed by yourself.
នៅអ្វីដែលលោកបានដឹងបានឮបានឃើញនៅក្នុងសម័យកម្ពុជាប្រជាធិបតេយ្យ អង្គជំរះសូមជម្រាបដំណើរថាបញ្ញាថា
The chamber also wishes to advise the prosecution that in the process of hearing this witness, the chambers would grant the prosecution the first order of putting the questions to this witness. So we now hand over the floor to the prosecution to put the question to the witness. You may proceed.
សូមអញ្ជើញ
President, I note that the defense counsel for Nunchi is on his feet. You may proceed.
Good morning, Your Honor. Thank you. And good morning, everyone. I have a brief submission with respect to what you've just said. That is the caution that you've just given pursuant to Rule 28. It's our position, and we submit that for the sake of clarity and fairness, this witness, this particular witness, should be well apprised of the OCP's stated position on self-incrimination. That is, that there always remains a possibility of a prosecution, however unlikely. And that's a quote from the International Co-Prosecutor on the 3rd of April, 2012. It's very much our position that this witness needs to fully understand what you've just said. And I think from his answers, it's clear that maybe he doesn't. Our position would be that because he's been given certain assurances by the OCIJ, he's been given certain assurances by the OCP over the course of events, the chamber really needs to go into this and to clarify it with the witness and to make it crystal clear that the prosecution's position is a possibility of a prosecution can never be foreclosed. Now, under Rule 28, and I'm quoting now from Rule 28.3, it says that where the co-investigating judges or the chambers determine that a witness should be required to answer a question, they may assure such witness, if possible in advance, that the evidence provided in response to the question either will be kept confidential from the public, not disclosed to the public, or will not be used, I'm quoting, will not be used either directly or indirectly against that person in any subsequent prosecution by the ECCC. So this court, the ECCC, is capable of providing assurances that there will be no prosecutions here. It's our position that it is not capable, it is not competent to provide assurances that this witness will not be prosecuted by the national courts. And that, of course, corresponds to the OCP's position. And I state it again for the record, there always remains a possibility of a prosecution, however unlikely. So I think it's very important that this witness understand this. And pursuant to Rule 28.8, and I'm quoting again, where a party is aware that the testimony of any witness may raise issues with respect to self-incrimination, or where the witness himself or herself raises the matter, he or she shall request an in-camera hearing and advise the co-investigating judges or the chambers of this. So I'm making that advisement now, pursuant to Rule 28.8. I think this witness, because he has expressed concerns in the past about a prosecution, because the OCIJ has made certain assurances, because the OCP have made certain assurances. I think the Chamber needs to the extent that it's possible, make certain assurances, and possibly we should perhaps move into that closed session now so that we can undertake that procedure pursuant to Rule 28.8. Thank you.
The President, the International Co-Prosecutor, you may proceed.
Yeah, Mr. President, I'm very troubled that counsel chose to do this in front of the witness in open session. I think that was a deliberate maneuver. The request for a closed session should have come at the very start if we want to talk about these issues. And if we are going to talk about this matter any further, it should be in closed session. He has taken a statement by one of my colleagues completely out of context. There is absolutely no reason for this witness to have any concern about this matter, and for counsel to bring this matter up in this fashion is highly improper.
The President, the lead co-lawyer for the civil parties, you may proceed. Mr. Ping. Good morning, Mr. President. Good morning, Your Honors. And good morning, everyone. The civil party lawyers are very surprised when the defense counsel for Mr. Nguyen Chea brought up this particular issue and this particular witness. As for other witnesses that the Chamber have heard so far, the defense had never made any such statement, and it is important that the witness answered the truth, nothing but the truth. And according to the law applicable before this Chamber, is that there are only two categories of individuals who may be subject to prosecution, namely those who were most responsible and the senior leaders of the democratic Cambodia. So only selected individuals who are subjected to prosecution within the framework of the applicable law before this Chamber. Therefore, with this particular witness, I am of the opinion that there won't be any questions that may incriminate himself. And I believe that in his capacity as a witness, there is no particular concerns for him before this Chamber. So I think that the matters raised by the defense is not proper. The President, the defense counsel, you may reply.
Thank you, Your Honor. First of all, I've revealed nothing of a confidential nature. I have not spoken of any of this witness's testimony. I've done that deliberately, in fact. That would be the purpose of moving into an in-camera proceedings to discuss this fully and frankly outside of the view of the public. So just to be clear, it was a deliberate statement that I made, and it was deliberately limited to avoid stating any of the facts relating to this witness. Secondly, I would just note that a similar discussion was had in the presence of Doik, and those quotations that I read out earlier were given by the international deputy co-prosecutor. Nobody raised any concern at that point that Doik heard those statements. I think that's entirely appropriate. The third point would be that all the parties have an obligation to raise this issue. All the parties, anybody, anyone in this courtroom who is aware, and I'm quoting again from Rule 28.8, that the testimony of any witness may raise issues with respect to self-incrimination. And that's very broad language. So I think everyone in this room is aware that the testimony of this witness may raise issues with respect to self-incrimination. So perhaps the prosecution should have raised it, perhaps the civil party should have raised it, perhaps the Chamber should have raised it itself. And finally, with respect to the last comment by the co-lawyer for the civil parties, as I said, I'm not speaking about further prosecutions at the ECCC. I'm not talking about jurisdictional elements of this tribunal. I'm talking about this tribunal's ability to provide this witness or any witness with concrete, actual, legitimate assurances that they will not be prosecuted by the national court system. And as said, as I've said, as the international co-prosecutor said, there always remains that possibility, however unlikely. Thank you.
The President. The chamber now hands over to the prosecution to put question to the witness. Mr. Singh Bun Kieng. Thank you, Mr. President, and good morning, witness. I'm going to put some questions to you. My first question is, when did you join the revolution? The President.
Could I at least be granted the courtesy of being told that my application was denied? Is that what's happened? The application was denied?
The President, according to the language I heard in Khmer, there is no specific proposal in your submission. So, in my capacity as the President of the Chamber, I do not really get the proposal you are suggesting or making. You simply use the term may or something to that effect. We cannot really get your proposal.
I'm sorry, Your Honor, that's my fault then for not being clear. Let me be very clear. I'm making an application pursuant to Rule 28.8 that we move into closed session.
You shouldn't be given the opportunity to repeat.
So that the issue of self-incrimination can...
The President, the request made by the Defense Counsel for Nuon Chea is not granted. The request to the Chamber that we move to the in-camera session. Second, the Chamber wishes to remind parties that whenever they want to make a request to the Chamber that any testimony hearing be conducted in an in-camera proceedings, the moving party should indicate that earlier enough before the witness is brought before the chamber. In addition, the moving parties shall make that request as precisely as possible to avoid any unclarity. Thank you.
Thank you, Your Honor. Just would like to note our exception to that ruling for the record. Thank you.
Now I hand over to the prosecution to put the question to the witness. Mr. Sein Bun Kieng. Thank you, Mr. President. The witness, I will repeat the question. When did you join the revolution? Response. In 1968. Question. When you first joined the revolution, who inducted you? Response. Ing. Ing inducted me. Question. Where did you reside at that time? Response. I cannot recall it. It may have been somewhere around Andomia district. I was very young at that time. Ing, you mentioned just now, what was his role in the revolution? Response. He was in the leadership level, but as to which specific level he was, I am not sure. Question. What was his particular role for Ing? Response. He was the leader in the Northeast Zone. Question. When you first joined the revolution in 1968, what was your designation? Back then, I was transferred back and forth from different offices. Question. Was you a member of the Communist Party of Cambodia or Youth League of the Communist Party of Cambodia? Response. No. Questions. So during the Democratic Cambodia, were you a member of the Youth League or Communist Party of Cambodia? Response. Back then, yeah, I was a member of the Youth League.
The President, could you please hold on? There is some technical glitch. We had problem with the rendition. I don't know what happened after the Khmer New Year. Can anyone advise the chamber on this? The President, National Court Prosecutor, you may now continue. Mr. Sein Bun Kieng. Thank you, Mr. President. Witness, Do you recollect when exactly you joined the Youth League? Response. I don't remember. It was in 1972, perhaps. Question. Who was the person who introduced you to the Youth League? Response. He was the person named Gu. Question. When you were in the Youth League, had you ever attended any study sessions or meetings concerning political lines and policies? Response. No, I didn't. Question. Have you ever received any party's documents? Response. No, I haven't. I received only a small diary or notebook concerning the education on ethical code of conduct. Question. Did you ever see the Revolutionary Flags magazines? Response. No, I didn't because I couldn't write or read back then. Question. Could you please describe to the court concerning your time when you served the revolution in 1968 until 1975? Where were you? What did you do? Response. In 1968, I was in the children unit. 15 children were gathered in the mobile unit. We would be moved places. We never stayed in one place for a long time. Question. Were you ever been drafted or signed up in the military to fight in the battlefields? Response. No, I wasn't. I was so young. Question. Before the 17th of April 1975, did you ever live in an office named B20? Response. No, I didn't. Question. Do you know B20? Response. No, I don't. I have heard of it. Question. Could you tell us how you heard of B20? Response. People from the transportation units talked about B20 because they said that B20 were tasked with transporting vegetables and livestock. Question. Do you know where B20 is located? Response. No, I don't. Question. Before the co-investigating judges, you made statement document E3/423 or D234/23 on question 137. You stated that you were at B20. Do you stand by your position? Response. I think B20 is somewhere located on the road to Tuol Song Kai. And since this happened long time ago, I don't recollect very well. Question. You mentioned about kilo dop or kilo number 10. Where is it? Response. It is in Kampong Cham. Question. Do you remember the commune names or villages? Response. No, I don't. I'm not interested. Question. Have you ever heard that people in the leadership of the party ever went to B20? Response. No, I haven't. Question. On the 17th of April 1975, where did you live? Response. After I left the children unit, I moved to the place called Kami. Response. Kami's location, you said. When did you go there? Did you go there before 17th of April 1975 or after? Response. Perhaps in 1975. Question. Before you moved to Mr. Kami's location, where did you live? Response. I had been the guards. I have been the guard at the guard unit all along. Question. Can you tell us the name of that guard unit? Response. I don't quite recollect it. I guess it's Yo 10 unit. Question. Was you in that unit when you moved to Phnom Penh? Response. Yes. Question. When you were in Phnom Penh, where did you stay? Response. I stayed at the place where people grew vegetables. I don't remember the name exactly. Later on, I moved to the K1 premises. Question. You indicated that before you moved to Phnom Penh, you had been at the vegetable growing location. Was it B20 or elsewhere? Response. It was B20 location. Question. At B20, did you ever see any people from the leadership coming to the area? Response: I have only seen ordinary people who were building the dam. Question: could you tell the court concerning your roles at B20? Response: I did nothing other than helping to transport vegetables and some ammunitions. Sometimes I had to help transport rice. Question: did you have any knowledge of the evacuation of the population from Phnom Penh back then? Response: I don't know. When I was in Phnom Penh, I noted that Phnom Penh was empty already. There were no people on the streets. Question: in the place where you had been staying before you moved to Phnom Penh, did you notice that people were being evacuated to the location? Response: I saw people were walking on the roads from Phnom Penh. Question: do you recollect how were those evacuees treated? Response: no, I don't know. Question: did you receive any instructions on how to treat people who evacuated from Phnom Penh in April 1975? Response: I was not told or instructed on this. Question: after the fall of Phnom Penh, after the Khmer Rouge took control of Phnom Penh in 1975, where did you stay in Phnom Penh? Response: I don't remember exactly when I came to Phnom Penh, but I am sure that it was after the liberation of the city. Question: could you tell the court what Phnom Penh was like when you moved in? Response: Phnom Penh was occupied by the military, no other people. Question: so there were no people seen on the streets? Response: there was very few people seen on the street. Question: few people, what were they doing? Response: I don't know. Question: from the date when you entered Phnom Penh in 1975, had you remained in the city until the collapse of the regime in 1979? Response: I had been in several places. I had moved to different places. Question: you said when you came to Phnom Penh, you worked at the Khmer location what is Kami location is? Response, it is your 10 unit, the guard unit. Question. Do you remember who brought you to Phnom Penh to work there? Response. There were two people, Brother Man and Gu. Response. These people accompanied or were with you when you were in Phnom Penh. Who accompanied you other than these people to Phnom Penh? Response. No, only those two people who were with me. Question. When you were brought to Phnom Penh, you said you were tasked with the assignment at your 10 unit. What were you tasked with? Or what did you do? Response. I was guarding the location. Question. Were you assigned to provide security or protection to the cadres and other senior people? Response. I was tasked with protecting your 10 unit. Question. Had you ever been assigned to guard any senior leaders? Response. No, I didn't. Or I was not. Question. Before the co-investigating judges in document D 234/23 or E 3/443. You indicated that you worked as the guard for Nuon Chea. Do you stand by your position? The President witness, could you please hold on? Counsel for Nuon Chea, you may now proceed.
Thank you, Your Honor. I was not in court for the DOIC examination, but I have reviewed the transcripts, and it's my understanding that these documents were put on the screen as they're being used. Is that not the practice? And I believe the witness is to be given a hard copy, if I'm not mistaken. And as my friend who's just arrived reminded me, he needs to tell us the ERN numbers.
The President, thank you, Counsel. National Co-Prosecutor, you are advised to follow our practice. Whenever a document is put to a witness, the ERN number and the code number of the document shall be read out in 3 languages, and that the hard copy of the documents should be made available to the witness before examination, and that witness should also be asked whether he could read or not. If not, it would not be useful to have the documents be put up on the screen, since he or she cannot read it. Mr. Won King, thank you, Mr. President. Mr. Witness, do you read or write? Response: I have bad eyesight. I'm afraid I cannot read the documents. Co-prosecutor: Mr. President, since the witness indicated that he cannot read, I am not sure whether it is still useful to have the documents be put up on the screen, or should I just read out loud to him? The President, as indicated, if the witness cannot read, it is not useful to have the documents presented to him in writing. It is indeed not useful to allow a witness who does not read to read any document. But it is still useful to read out the ERN numbers of the relevant documents, and in particular the identification of the document, so that parties in the proceeding are well informed. These have been our set precedent, and that they should be well followed unless there is any other decision otherwise to improve the situation. Counsel, you may proceed.
Thank you for that, Your Honor. Do I understand that to mean that the document will then be put up on the screen so that we may all have access to it, as you've just said? And I think the witness has indicated that he has difficulty reading. Perhaps if he had a hard copy in front of him, he could read it. I do recall reading in one of his statements that he is literate in Khmer. So perhaps if he had the hard copy in front of him, maybe he said it's a problem with his eyesight, so maybe he's having difficulty seeing the screen. I don't know. Perhaps he could be asked.
The President, National Co-Prosecutor, I think you should not really open this Pandora's box. Just follow the practice. Put the document up on the screen. It's very simple as that. Please show the identification of the document, the ERN numbers, and have the documents be put up on the screen so that the parties and the public can read them or see them. National Prosecutor, document D3/443 or D234/23. This document contains the questions and responses in numerical orders. If we look at the response on item 21, witness indicated that he represented the guard unit for Mr. Nguyen Chia.
Excuse me, Your Honor.
The President, you may now have the floor, but please be brief, because you have taken the floor very often and we haven't moved much this morning, and we want to ensure that questions are put to the witness. Otherwise, the proceedings are dedicated to objections rather than putting questions.
Thank you, Your Honor. I'll indeed be very brief. I think I briefly need to return to the issue I raised this morning. I think we're moving into an area where this witness may, and I say may, incriminate himself. He needs to be apprised of his rights. And I'm quoting now from Rule 28.9, which I did not cite earlier this morning. And that rule says, if an issue of self-incrimination arises in the course of the proceedings, the co-investigating judges or the chamber, in this case the trial chamber, shall, to emphasize, unless the witness waives his right, suspend the taking of the testimony and provide the witness with a lawyer. So further to what I said this morning, it's our position that this witness has not been fully apprised of his right, and that at this stage, it seems that we may be moving into an area of self-incrimination. So I would suggest that the witness be fully apprised of the right, including his right to a lawyer if he so chooses. And that, again, is indeed, Your Honor, an application pursuant to Rule 29.9. Thank you.
The President, International Co-Prosecutor, you may now proceed.
Thank you, Mr. President. We highly object to this interference that is going on by the Defense Counsel. If they wish to raise these matters, the Court had just indicated earlier it should be done in closed session. This is a transparent effort to interfere with this witness's testimony. It's outrageous, and my suggestion is that we break and have a hearing or discussion of this matter outside the presence of the witness, because this type of interference simply cannot continue.
The President, lead co-lawyer for the civil parties, you may now proceed.
Thank you, Mr. President. I find this intervention at this stage unfair, because to give the impression to the witness that he risks being charged is unfair. It is false that we should go into closed session here because the witness runs the risk of incriminating himself. To say this before everyone present here is not fair. I suggest that the Chamber should resolve this issue once and for all by stating to the witness that according to Rule 28.3 that the witness will not be prosecuted before the ECCC, and that he enjoys such guarantees. This would put the matter to rest. I find the statement by the defense very unfair and improper.
The President, counsel for Mr. Ieng Sari, you may now proceed.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. My apologies for arriving slightly late this morning. Last week, when Doik was testifying, the prosecution, Bill Smith was here, but the gentleman that stood up today was also present when they indicated in public that Doik enjoyed the right not to incriminate himself. They didn't ask to go into private session. They initiated that intervention. And in fact, they said, however remote prosecution may be, the person enjoys. What we hear from the civil party is absolutely incorrect, because the rest of the story is that the gentleman could be prosecuted in other courts in Cambodia, maybe not before the ECCC, but nonetheless runs the risk. Now, if it was good enough for Doik, why isn't it good enough for this gentleman? And if we're going to have a transparent proceeding, why not do it transparently? I think the better practice is, in advance, for the parties, if they wish, to state to the trial chamber that the witness may be incriminating himself or herself, and for the trial chamber to, from the get-go, give the warning to the witness. That way, the witness knows well in advance. If they wish to seek legal advice, fine. If not, let the questions begin. But that's the better practice.
Thank you, Your Honor. If I may reply very briefly. Of course, I support the comments by my colleague, which reflect what I said earlier this morning. I would also say that I reject the assertions by the prosecution, for the record, that I'm behaving in any inappropriate manner. However, I fully agree with the prosecution that we should now move into closed session so that we can discuss this properly, openly, amongst ourselves, and clearly. Thank you.
Mr. President, I wasn't suggesting we go into closed session. I was suggesting that we have this discussion outside the presence of the witness. And I do not understand why defense counsel think it is their job to serve as counsel for the witness. When Doik was testifying, he was asserting himself his rights in relation to questions regarding M13. This witness has not asserted his rights. It is the defense that is attempting to intimidate by raising these issues. That is our concern, and it is our concern that this is not an appropriate issue to be talking in front of the witness. So that is our position on this.
Your Honor, I have one new point. I'm not attempting to intimidate anyone. I'm just following the rules. These are your rules. These are the rules of this court. Where a party is aware, that party shall do what I've done. So that's my clear position on this point. And I would appreciate not being accused of inappropriate behavior time and time again when I'm simply just following the rules. I'm not trying to intimidate anyone. Let me make that very clear.
The President, is there any representative from any parties or wish to make any further observation on this? You may have the floor. The President, since there is no further observation on the from parties, the Chamber will have the adjournment for half an hour, and the next session will be resumed by 11 o'clock. Counsel for Evidentiary, you may now proceed. Counsel Angadam, Mr. President and Your Honors, due to my client's health concern, we my client has requested that he be excused from this courtroom and be allowed to observe the proceeding from his holding cell for the rest of the day. The President, the Chamber has noted the request by Ieng Sary through his counsels. Ieng Sary has requested that he be excused from this courtroom and be allowed to observe the proceeding from his holding cell. The Chamber therefore grants such request. Ieng Sary is now allowed to observe the proceeding from his holding cell, and counsels for Ieng Sary is advised to produce the waiver signed or given thumbprint by Mr. Ieng Sary. And AV Booth is now advised to ensure that the video link is well connected to the holding cell so that the accused can observe the proceeding. And security personnel are now instructed to bring Ieng Sary to his holding cell so that he can observe the proceeding from his holding cell. And court officers is now instructed to help a witness during the break so that he can be taken to his waiting room and have him return to the courtroom by 11 o'clock. The court adjourned for 25 minutes rather.